everybody. It is Joy and Scott from Anderson Injury Law, and we are starting a new topic that we really haven't covered before, and that's premise liability. So, when Scott and I were talking beforehand, I said, let's just talk about what it is. I think people have misconceptions or they don't know everything that it includes. So, what is premise liability? Is my first question.
So the premise liability, we call it premise liability, at least in Colorado, because it's the Premise Liability Act. And I mean, it stems from farther back than that. But at this point, Premise Liability Act controls. And what it basically does is say if you are injured on the land of another person, you have a claim against them for those injuries. And so usually you're talking slip and fall. You're talking about you trip over something and get injured. It could be something where someone's going to work and they're a construction worker and they show up on scene and lo and behold, there's some of the stairs that are not nailed in properly, and so they try to go up the stairs and through the stairs they go. Could be sometimes it can be dog bite cases, depending on where someone got bit by a dog. Um, Basically, if you are injured because someone else who owned the land, and landowner is a specifically defined term, so it's not as intuitive as, hey, you have the title to the property. It's bigger than that. But it is, if you are injured on the land of someone else because they didn't do something to protect you, that is a premise liability claim. Landowner gets defined more than just who holds the title to the land. It's basically anyone who has control over the land. So, for instance, you have janitors who are supposed to come through every hour and clean up a grocery store or something like that. Um, then someone spills, I don't know, water, a can of soda, something like that all over the ground. And it's sitting there for hours and hours or days, and no one has cleaned it up. Well, if the janitor crew had control of the property where they were supposed to come through and clean up that spill, they are a landowner that you have a claim against for that failure to protect against a dangerous condition. And the failure to protect against a dangerous condition is language from the statute. And so that's what you are looking for um, whenever you have a premise liability claim is, was there a dangerous condition? The landowners, I can tell you, it becomes complicated because there are frequently more than one landowner. So a grocery store, in my example, you have the person who owns the land. Oftentimes it's not the grocery store itself who owns the land. They're usually leasing the land. So then you also have the company that is the grocery store. Then you would also have in my example, the janitor staff who was supposed to come in and clean up the spilled drink or spilled substance. So there can be more than one landowner under premise liability claims.
You know, that's pretty interesting. So that's why you see on cases there's so many named defendants because the landowner, the leaseholder, and I'm kind of thinking just because of the weather, look at ice. I mean, God, talk about the United States being blanketed with ice this weekend. So how does a business protect itself? What can a plaintiff uh, do? And my point is, like, we kind of feel like it's our fault. Like, if we slip and fall on a sidewalk or a parking lot or whatever, like, when is it not like the person's fault and when is it the business's fault? You know what I mean?
Yes, it becomes a little bit convoluted because of the way the Premise Liability Act was written. At least in Colorado, the Premise Liability Act was written in a way that breaks people into three categories of person. The first is a trespasser, which what is owed to a trespasser there are some duties you can't set up, like a booby trap to intentionally injure people who come onto your property. But beyond that, it's very little is owed to a trespasser. Then there are licensees. Licensees are social guests, is a good example. You invite someone over to your home, they are a licensee. The best category for a injured person to be in is the last category, which is an invitee. An invitee is basically the grocery store example. You're a customer walking into the grocery store. The grocery store has invited you in to shop, to buy their goods. You are an invitee into their premise. And so your question is a great question, but it depends on how you are categorized, because the Liability Act changes the standard for each of those categories. So, for instance, a invitee, there has to be a dangerous condition on the property for which the landowner either knew or should have known that the dangerous condition was there, and that they should have either warned or protected the person against that dangerous condition. So, the example of it's let me actually take a step back. Grocery stores has a lot of there are a lot of cases against grocery stores, and I always thought it was funny before I went to law school. I thought banana peel cases were something that were just made up in cartoons, and there are a huge amount of banana peel cases. And so what happens is banana peels are apparently extremely slippery when they have sat on the ground for a while. And it's something I would never have thought about before becoming an attorney, but they are. And Mario Kart got it right. Um, so what ends up happening is your question comes back to the base term of reasonableness. The store, the landowner, the whoever it is that you're looking at making a claim against, did they act reasonably or not? That's really what you're asking.
Mhm.
And so, grocery store has a banana peel that falls off the rack, lands on the ground, and 10 seconds later, a customer turns the corner and steps on the banana peel, falls, and breaks a leg. That's not the grocery store's fault, because it just happened, and uh, there was no reason for the grocery store to make efforts to protect against a banana peel that they didn't even know was there until 10 seconds before it happened. Contrast that to banana falls off the shelf, and 2 months later it's still sitting there. No one's looked at it, no one's picked it up, no one's done anything. It's now black and moldy. Someone turns the corner, slips and falls, and breaks their leg on it. Now the store is responsible because they should have easily found it within that time frame. So reasonableness dictates everything, and it's not a nice clean answer to your question. But frankly, the law doesn't usually have clean black and white answers. It's usually very muddy and gray. And so the Premise Liability Act, what do you do as a business to protect yourself? You take reasonable efforts. What are reasonable efforts? I mean, if you're actively trying to protect people from injury on your property, you are probably in doing what you need to do. If you are just ignoring problems that exist on your property, then you're opening yourself up to claims. So your example of, hey, snow, um, you should probably get out there, shovel the snow, put down some at least on the places where people commonly walk. If someone is cutting the corner and walking through what is not a walkway, you have a whole nother scenario. But if you should be shoveling your walkways, putting sand or some kind of ice melt down, something like that, and that way people have a lower likelihood of getting injured on ice.
And I think cameras add a whole new dimension to that, good and bad. You know, I mean, if you're really trying to take care of your property, cameras are your friend. And if you're not, cameras are not your friend.
Yeah, I think cameras are extremely helpful. So I think businesses especially should have cameras everywhere. If businesses don't have cameras, they're setting themselves up for bad claims. And unfortunately, there are some bad actors in this world who will fake an injury, or maybe not even fake an injury, but injure themselves by spilling water and then intentionally slipping on their own water. There are some bad actors in this world, and I think they are very, very few and far between, but they do exist. Unfortunately, there's a lot of media presence that makes it seem like everyone is a bad actor and trying to get money for nothing, and that's not realistically what happens. I can tell you my personal experience is people almost always, when they slip and fall, have exactly what you started out saying of, I'm so embarrassed I fell, I don't want to make a claim, but look, I'm hurt and they're treating me like crap, and they won't even pay for my medical care, much less and give me a any form of sympathy. uh, I can say the most common premise liability case I have represented someone for starts with the employees and the managers ran over, and they started, they didn't even call an ambulance. They didn't ask how I was doing. They didn't ask to help me up. They just started taking pictures and doing reports
Oh
and
my God.
ignoring the person who was hurt. And that's usually the start of most of the claims, is the stores caring less about the human being than they do the potential of being having a claim made against them. So just treat people nicely, and things tend to work out.
That's the lesson for today.
Right.
All right. If anybody has a question about premise liability and what that means, please reach out to Scott. The best way to get a hold of him is
Phone 719-473-3040, or you can go to the website injuryevaluation.com.
awesome. All right. I will see you next time.
All right, we'll see you next time.